think there's a couple of us that have similar questions, and I apologize if you might have mentioned this at the beginning. I was a couple minutes late figuring out technical difficulties. A bunch of us are starting brands or helping to start a new brand, and we've gone as far as to do the database search and maybe even work with Swift filings or SBA.gov to register the name. And then we've also bought a domain. Is that enough for now until we're ready to produce or even sell a good, and then you can go for the trademark? What's like the right steps to follow to make sure that when you get to the point of having to trademark the name, you actually can use the name that you've been using, let's say for the year, while you're getting your brand up and running?
So that comes up all the time. I hear that same question all the time, and it really, it's a lousy answer, but it really depends on the circumstances. But the general answer that I tell people is, it's better to file for a trademark early. Like, recognizing that resources can be tight when you're starting a new business, like dropping $1,000 or something on a trademark application doesn't seem like the best investment when you've got other things. But it's a first come, first served system, more or less. So whoever gets to the trademark office and files first is going to have rights first. The domain, the availability of a domain is a good indicator that a mark is available. It's not conclusive at all. But what's the first thing you do when you register a business? It's you go after the domain. So it tells you something about it, but it doesn't give you any inherent rights in the mark, really. It'll give you some. It's not until you start selling something that you have any real common law rights. So if you're just kind of using it and prepping a business, you're better off going to the trademark office, filing an intent to use application, saying like, look, I'm going to do this. I'm not selling it yet, but I'm going to. Knowing that, the process takes 9 months anyway. So if you're on that, if that's your timeline, that's probably the best course, because the other things don't really give you any protection. They're evidence of use and they're types of use. And if you're doing those things and someone else has rights in that mark, it could be infringement, but it's better. Early is always better if you can afford to.
And then I guess, so I filed a DBA doing business as, does that give me any protection to the name or any?
If you're selling something, if you're actually using it commercially and selling goods or selling services, it might. But, again, if you're not out using it commercially, you don't really have any rights in it yet. The only way to get real trademark rights in the United States before you're selling something under the brand is to file an intent to use application with the trademark office.